Welcome to the Legal Shark Tank, Strategies for DUI and Beyond with Shane the Shark, where we'll discuss the complexities of the legal system, demystify the process of criminal defense, and provide you with the tools and confidence to navigate your case.
Welcome to the Legal Shark Tank, Strategies for DUI and Beyond with Shane Hersner. I'm Sam Henninger, and today we're going to talk about DUI. In fact, just before we started recording, Shane, I was asking you, because I use the term DUI, that's just the one I'm familiar with, and I think a lot of us are, but you use the term OVI. And so let's get started with distinguishing these two related but distinct types of charges that somebody can come up against.
Yes, OVI and DUI are kind of synonymous here in Ohio. A lot of people will refer to it as a DUI, but the technical term is operating a vehicle while impaired. And the reason why it's called that is in Ohio, you actually have to prove operation of the motor vehicle. So somehow you moved it during the time period that you were impaired, and then they also have to show, obviously, that you were impaired. They've also created a secondary offense to where if they are not able to show operation, they have an offense called physical control, which essentially says you have physical control over the motor vehicle, but you were not operating the motor vehicle. OVI has mandatory minimum penalties for offenses, whether it's your first offense, second offense, or more. Physical control for a first offense, there are no minimum penalties. So I think it's the state's way of I don't want to say rewarding people, but encouraging people not to actually drive the car if they felt that they've had too much to drink, but to perhaps maybe sleep in the back seat or do something where they're not actually in the driver's seat with the car running or operating the vehicle. So they do not have any mandatory penalties for physical control. Ohio is the only state that I know that has a physical control charge. So it's kind of unique here. And if I get an out-of-state client who happens to be in Ohio and we're either able to amend it to a physical control or it's charged as a physical control, a lot of other states don't know how to treat a physical control. So that's always a kind of a challenge when it comes to license suspension, things like that, in the actual state that the person lives in.
What common misconceptions do people have around DUI laws?
The one that I get the most is that clients just assume, well, hey, I had something to drink. I'm sure I was impaired. And they automatically assume, like some jurors do, that you're impaired if you've had anything at all to drink. That's not the case. In order to show impairment, they have to show that your motor skills or your ability to multitask or to think is impaired, that your ability is appreciably impaired is how the statute defines it. So that's not an easy thing for the state to prove sometimes. So it's incredibly important to look at all the evidence in your case before you just assume or you want to throw in the towel and just plead guilty. And that's why it's important to hire an attorney that actually does DUI defense. And their primary focus with their practice is in DUI defense, because a lot of attorneys will just look at a case and say, yeah, you're right, let's try to get a reduction right away, without actually really looking into the case and finding out what possible defenses that you may have. So that's probably the biggest misconception is clients, unfortunately, think even before they've been found guilty by a jury or given an opportunity to work out something in the case, that they're automatically guilty.
Now, we had touched on this on our previous episode, but would you mind refreshing us, the listeners, on what the standardized field sobriety test is in Ohio and how that's actually used to determine impairment? Because like you said, it can be tough for the state to do that sometimes. And so let's break that down some. Yeah,
the standardized field sobriety tests, as I'd mentioned earlier, there are three recognized standardized field sobriety tests. The horizontal gaze nystagmus test, which is referred to the pen test or the eye test. Now this test, what they are looking for, and most clients will tell me, well, hey, I followed the pen, so I passed that test. That's not what an officer is looking for. An officer is actually looking for an involuntary jerking of your eye. So you don't even know it. But as the officer takes that pen or the stimulus across slightly above eye level, about 12 to 15 inches out, they're looking for your eye to slowly jerk back. Whereas if you didn't have anything to drink, it'll go real smooth like a marble on a table. Instead, if you've had something to drink or if you're impaired, it'll go more like a windshield wiper, how it kind of scrapes a little bit across the windshield. So that's really what they're looking for on that test. There's some issues that we can go into later concerning the horizontal gaze nystagmus test, but quite frankly, of the 3 standardized field sobriety tests, that is probably the one that is most accurate to determine if somebody has had too much to drink, but it is also the one that's, when given, officers do it incorrectly all the time. They do it incorrectly all the time because there's specific timing on this test, and it really has to be done correctly in order to get good, reliable results. The second standardized field sobriety test that they'll generally give somebody is the walk and turn test. And that's a walking test where you take 9 heel-to-toe steps forward, do a turn, and 9 heel-to-toe steps back. And then they do the one-leg stand test. The one-leg stand test is a time test where you stand and you pick one leg up approximately 6 inches off the ground. The major issues with those 2 particular tests is that when they were validated in these studies that occurred years and years ago, like I said, 1980s, and they've done some in the 90s, the people who are given these tests, they're given the test in a hotel or in some sort of controlled environment. So there aren't environmental issues that could cause issues with the test. These people are also not going to get arrested if they fail the standardized field sobriety test. So nerves don't play a part into it. The flashing strobe lights are not in their face, and they don't have an officer standing right over them as they perform. So I have a lot of questions concerning the reliability of these particular tests because of that. They're in a controlled environment where when you're being arrested for an OVI or going through these tests, you're doing them on the side of the road. What's on the side of the road? A lot of debris, pebbles. There's traffic that goes by. And if you've ever stood on a highway with traffic going by at 60, 65 miles an hour or more, you know how much wind and how that affects your ability to stand up. So there are so many issues with these standardized field sobriety tests that I don't think that a client should do any of them because chances are the deck is going to be stacked against them for performing well on these tests.
Now, as you explain all that, I think it makes a lot of sense. And I think a lot of people would say that's common sense that these factors would affect the reliability of these field tests. I'm curious, though, how you actually go about building that into your defense, because it's one thing to have the common sense idea of it, but then to actually present it.
The one good news with me and with most DUI attorneys that practice it is that I'm certified in the standardized field sobriety test. So I took the actual testing that officers take to get their certification to have clients do these standardized field sobriety tests. So I'm NHTSA certified. Why that's important is I know these tests better than almost all officers because that's what I do every single day. Whereas some officers that will be in a trial that I'll have, it'll be, well, I've made 20 DUI arrests in a year. We do almost 100 DUIs in a year. So nobody has seen more videos. No police officer has seen more videos. No police officer has analyzed more standardized field sobriety tests than we do as defense attorneys, DUI defense attorneys. So because we know these tests so well and we know the breakdown of it, we can easily point out the instruction issues that officers have and also the environmental issues that may cause a client not to perform as well.
That's really cool. And that makes a lot of sense to me now that you're not only certified in it, but of course you're dealing with these types of cases way more than your average police officer.
Yeah, they maybe do a trial. You know, I actually had a case a couple of weeks ago and it was the officer's first trial and he'd been on the road for a year. Man, we're probably litigating at least several cases a week, either through a motion to suppress, through some sort of administrative license suspension appeal, trying to keep a public safety suspension in place or trial. We really do quite a bit of this. And that's important because repetition it helps us to get better at knowing what to look for in these particular cases, and it keeps us fresh. So I think that that's really, really important to continue to litigate cases. Cases that should be litigated, we litigate.
In our previous episode, you ended off with some great advice for people who maybe pulled over, suspected, or charged with an OVI. But I wonder if you'd refresh us or maybe add some even more context advice as to what are the do's and don'ts when you get pulled over suspected of an OVI.
Sure. I think that that's important. That's something that people need to know, because it's easy to advise them after the fact, but I always like to try to get the information to them before they're ever put in this particular position. So if you're pulled over by a law enforcement officer, police officer, first and foremost, if they come to your window and they ask you for your driver's license, give them the driver's license. Give them any identifying information. If they ask any additional questions about where you're coming from, things like that, I would generally tell a client, you don't have to answer those, and you don't need to answer those. So just tell them, look, I don't want to answer that, or I'd like to speak to an attorney before I answer any questions. If they ask you to get out of the car, please get out of the car. Definitely get out of the car if they ask you to do that. I would watch how you get out of the car, make sure that you're getting out appropriate, because they're going to be looking for, do you use the door to get out of the car, different things like that. So there's things that they're looking for even in that process. But get out of the car. If they ask you to do field sobriety test, do not do the standardized field sobriety test. Again, I think that they hurt people more than they help, and for reasons other than alcohol impairment. Sometimes they'll even offer you a portable breath test, which is we call them PBTs, which is a machine or a little handheld device that they have you blow into on scene. I tell people definitely don't do those, because those are not even admissible in court for reliability purposes. So don't do PBTs, and don't make any statements other than the necessary statements of identifying who you are and where you live and the fact that you want to speak to an attorney. Other than that, it makes their case much, much more difficult if you do not give them any other information and or do any field testing or breath testing.
As you're hearing it, I'm going through my mind, okay, this is what I should do if I'm ever in that situation. And what's coming up at my heart rate, my blood pressure is increasing just thinking about it, because I think a lot of us, we worry about, if I get pulled over, the best thing I can do is just comply. Just try to do everything I can to do what they say. But what you're advising is there's things they're going to ask you to do that are going to hurt your case.
You're exactly right. Clients, because most of the time they're first-time offenders, like you'd indicated. So well, hey, it's a police officer. Of course I'm supposed to do whatever the police officer says. And yes, that is correct. You can be polite, because oftentimes I'll hear officers say, well, they were uncooperative. And I'll ask follow-up questions. Well, what was it that they did that was uncooperative? You mean not doing standardized field sobriety test? Yeah, well, those are optional, aren't they? Yeah, they're optional. So then really, my client was not being uncooperative. He just exercised his or her rights not to do these standardized field sobriety tests. And then their answer is always yes. So I think there's a fine line of being cooperative, which means giving them identifying information, and refusing to do things that you don't have to do. You can still be polite, cooperative with the officer, and not do these standardized field sobriety tests. And that's generally what I would recommend that you do. And it only helps your case, because like you said, they're looking for things. So sometimes there'll be the most minute thing that you think that you're doing that they're writing down, trust me, on their investigative notes that, hey, notice it took him an awful long time to pull his driver's license out of his wallet. And it could be because he's having conversation with the officer and looking at the officer instead of in his wallet. But the officer doesn't give you any credence for that. It's just, well, hey, it took them too long to pull out their driver's license. So keep that stuff in mind. And that's why I said you can be cooperative with law enforcement and still refuse to do these particular tests.
Now, you've explained this, the things, the do's and don'ts there, but maybe let's speak broadly about what are your rights when you are charged with a DUI or OVI?
Yes, you do have the right to counsel. So if they're asking you questions concerning where you're coming from, different things like that, you do have the right to tell them that you want to speak with an attorney. And that's probably the best right that you have. Chances are that they are going to arrest you for a DUI. If they're getting you out to do field sobriety tests and you refuse to do those tests and you refuse to do a breath test, they're likely going to arrest you. But know that you do have that attorney that is going to be fighting for you on the other end. And your case improves dramatically if you do not have field sobriety test and you don't have a breath test. In Ohio, they can charge you under the breath test section for per se, so being over the .08, and they can charge you for their opinion-based OVI, which is known as the A1A section. If you take a breath test, they charge you then for the per se and the A1A. So I'm not only fighting an opinion, which is the A1A, but I'm fighting a number. And as we talked about in an earlier episode, those numbers are difficult to beat because of the challenges that we face here in Ohio. Where opinions, if you refuse, I can beat opinions because two people can look at a video and have completely different views of a video, where numbers are much more difficult to beat.
As these things go, how do you commonly build your defense to challenge these charges? Because it sounds like if they haven't heard about this, there may be the tests done and you have to fight against that.
Well, the good news is I've gone through the NHTSA training, so I do know everything that the police officer is looking for from the time that the vehicle's in motion all the way to the arrest and post-arrest observations too. So that's kind of how I break down a case, is how the NHTSA manual breaks it down, because that's how the officer is going to write it in their summary. So for instance, I believe there's like 30 some odd observations that they're looking for when they make initial contact with a person, personal contact. Most of the time, they only observe one or two of those, and it's always the bloodshot, glassy eyes. That seems to be the most common thing that they write down. And of course, at 2 a.m. in the morning, most people are going to have bloodshot, glassy eyes, because I know I do if I'm up that late. So there's lots of different things that I look for when it comes to going through that process of vehicle in motion, stopping sequence, how the car stops, personal contact, what do they see when they come up to the person, what do they observe, how does the person exit the vehicle, how do they look when they're walking to the back of the car, and then they go into the field sobriety testing. So that's the way that I like to break down a case for defense. When it comes to field sobriety testing, it's just that the officers do not do these, the training isn't there to where they do these field sobriety tests on a regular basis. And so they are always and constantly making mistakes. HGN, horizontal gaze nystagmus, like I said, is the most common test. I couldn't tell you how many times I've ran the times on certain portions of this test and seen that they're horrendously off, or they won't do the right number of passes, or they won't stop and check for equal tracking or any kind of nystagmus from the beginning, or equal pupil size. There's a lot of different things because they just assume, well, hey, if I ask this person to do that or do that, that's substantial compliance. So can they get the test in? Yeah. But that also gives us lots to work with when it comes to the performance on the test and why a person would do poorly. Because if the officer doesn't instruct you to keep your hands down by your side, but marks you down as a clue, that gives us reason and arguments to make as to why you exhibited that clue.
That's really good to know. Would you mind describing to us what a DUI OVI conviction does to your life, how that impacts you, and maybe distinguish between a first-time offender and someone who's beyond that?
Yeah, a DUI could be horrendous on somebody. I mean, first off, the mandatory minimum penalties for a first offense, 3 days in jail or driver's intervention program. Now, most people do the driver's intervention program, so very few people do the jail. But there is a license suspension of at least 1 year. A DUI is not expungible, so it stays on your record forever. It is also enhanceable. So if you were to get a second DUI, instead of 3 days, and there is also a 6-day penalty if you blow high tier. Instead of 3 days or 6 days, you're looking at 10 to 20 days for a second DUI. The suspensions are longer for a second. Your vehicle could be immobilized for 90 days if the vehicle is registered to you. You also would likely be required to have an ignition interlock, which is the blow device to start your car. And you could potentially have what we call the restricted plates. I called them party plates when I was in college. They're in Ohio, they're bright yellow with red lettering, but it's almost like a scarlet letter of, hey, this person has DUIs. So it is incredibly important, particularly on a first offense, is to do everything you possibly can do to try to get that charge reduced, because chances are, hopefully you'll never have a second one. And if you can get it reduced, then you don't have that DUI in your record, and it also would not enhance a penalty if you were to get one in the future. DUIs, believe it or not, are also considered a major offense in Canada. So if you were to try to go to Canada after getting a DUI, you're going to be denied access into Canada. So there's a lot of different, I guess, things that people never think of when it comes to consequences for a DUI conviction. I mean, we know the normal ones, the potential 3-day program, the insurance costs going up, things like that. But you don't think of the smaller ones. And I always tell clients, if you're applying for a job and the employer looks at your record and they see that the other client or the other potential candidate doesn't have a DUI and you do, is that going to be a deciding factor? I don't know, but it could potentially be. So if you have any chance at all getting that DUI or keeping that DUI off of your record, you need to explore that. No matter how guilty you may think that you are, you need to hire an attorney to find any and every defense that they can to keep that first one off of your record.
This has been the Legal Shark Tank, Strategies for DUI and Beyond with Shane Hersner. I'm Sam Henninger. Remember to like, subscribe, and share because we're going to continue these great conversations. Thank you, Shane.
Thanks, Sam.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.